Thank you so much for having me. I want to extend a special thank you to Professor Martinko and to the LePage Center. I'm really excited to get to be part of this conversation you're having this year about decolonizing history and land and approaches to scholarly research.
Great, thank you. Well, I thought we could start off today by asking you to tell us how you became a historian and how you came to your research focus.
Absolutely. I did not think that I would have ended up here if you had asked me 15 years ago. So while I was an undergraduate at Tulane University, I got pulled into a project working with a local indigenous community there, the Pontiac, who were in the process of filing for federal recognition. Now, what this means is that if a tribal nation doesn't already have a relationship, like a treaty relationship with the federal government, there's this extended, in-depth, historically focused process that tribal nations can go through where they compile all of these materials about their history, about their culture, about their present, and submit these to the federal government to prove their indigeneity to the experts in the federal government. This process, if it sounds a little bit bananas, it's because it absolutely is. But I basically was coming into this process as someone who's also indigenous with a background in Native American, history and culture, but not someone who knew anything in particular about this region. I was there to do legwork and to assist on gathering documents. So the person working in the archives on this project, or one of the folks, I should say. And this was, of course, led by the Pontiac. Anyway, I showed up to this region, and my folks are all from Oklahoma. I was very much under the impression at this point that I understood indigenous communities and that many of us were in the West with a couple of isolated communities to the East. At that point, I had absolutely no idea and no understanding of all of the communities throughout the Southeast and throughout really most of Eastern North America who've avoided removal. And so I ended up doing the historical work that I'm doing now by asking, Dr. Martinko introduced my work on the history of the 18th century in Louisiana. This stems from the question of how did these communities come to form? How is it that they managed to survive in their original homelands and retain community when so many folks were removed or faced other kinds of tremendous violence that made it impossible for them to stay? And what are the things that are definitive about this kind of indigenous, these folks and Native history that's different than other tribal nations across? So I ended up pursuing that project throughout graduate school, and that's taken me to this career in this intersection of history and public history and sort of academic-based activism. But I think it's a pretty clean line of not starting this so much from a pure intellectual place of I'm abstractly interested in this community, but coming in rather as someone dedicated to doing groundwork, and then my academic questions emerging from the experience with the community that I then have pursued elsewhere.
Yeah, that is a really fascinating sort of look at one intellectual journey, right? And I think for, many people, as you say, the interest starts with the intellectual questions and then maybe moves into application where you really have this sort of journey from the legwork, as you put it. I'm curious, you said that you participated in the process of sort of seeking federal recognition and that this was something that tribes pursue when they don't have a treaty relationship with the United States. I'm wondering if you can explain to us why tribes may or may not have a treaty relationship. What is determinative of that today?
Yeah, absolutely. And I think especially since, this is a conversation based out of Philadelphia and in the East Coast, this is especially relevant. So we frequently think of Indian nations as existing on reservations and being governed by treaties that they signed probably under duress, most likely during the 19th century, with the federal government that might have established reservations and boundaries or been signed at the end of a formal war. Now on the East Coast, because Indigenous people have been dealing with settlers for such a long period of time, there wasn't the same kind of rapid interaction. Like, for example, we'll probably talk about Lakota and Dakota people when we talk about the Dakota Access Pipeline in a little bit, but I think they're a good example of people who first had a relationship with the federal government after the Louisiana Purchase in 1803 and then signed treaties with the federal government to facilitate trade in the 1850s, and then ultimately end up on reservations again based out of this series of 19th century treaties. Now, for groups who are in and around the East Coast, folks like Lenape communities, some of whom remain in New Jersey, some of whom remain in Pennsylvania, for communities like the folks that I work with in the Deep South, Tunica, Biloxi, Pontiac, Ile-Jean-Charles, all of these groups have had much longer interactions with settlers in the region that they're living in. And so in particular for Lower Louisiana, one of the things that I've found is that these groups were able to avoid removal by existing in backwoods, backwaters, and on the peripheries of settler community in smaller numbers, so that they're taking kind of an opposite approach to larger nations in the East, like the Cherokee Nation that in the 19th century attempted to draw and enforce really hard borders and boundaries to the federal government. So what this means is that for groups, and there are many I've referenced a couple in Louisiana and then in Pennsylvania as examples, but I want to be clear that this spans a huge variety of nations in both the East and the West. Anyway, to Dr. Martinko's original question, if these nations didn't have ongoing relationships with the federal government and their relationships were with local people who they had had long-term interactions with, it's possible that they would not have developed the kinds of treaties that would enable them to have recognition from the federal government. And so in the 20th century, they had to go through a process for federal recognition. For example, if we think about another, this will be the final historical example I'll give, but totally iconic group, Mashpee Wampanoag people, folks who were the people who received our Pilgrims, Mayflower settlers, made some of the first relationships with English settlers, on the eastern seaboard. They were forcibly incorporated into Massachusetts in the 19th century against their consent. And so they then in the 20th century had to reapply and say, we've not gone anywhere. We've been the same community. We're living on the same lands. But because of the way that we were incorporated into the state of Massachusetts, we lost our special status as separate other tribal nations. So basically there's a whole variety of backgrounds, but a lot of tribal nations did not have formal relationships with the federal government in the 20th century. And so have had to go through this process of applying to be federally recognized. And what that does is that gives you rights to control land, waters, regulate, things like interactions between Native folks on your own territory, to manage resources, and to have access to things like Indian health services and other kinds of specific programs that the federal government supplies for Native people. So that's a really long and complicated answer, but I think it speaks to the super different histories that Indigenous people have with the federal government, so that there's really not a one-size-fits-all way to think about the interactions between different Native nations in the federal government that have led to these very different outcomes.
That's great. Yeah, that's a fantastic look at that diversity. And, you brought up the Mashpee Wampanoag, and I think that they are an example perhaps of the ways where it's not just a matter of either you have federal recognition or you don't, right? That there's even complexity within that. And some of us may have seen Mashpee Wampanoag in the news recently within the last year, particularly in the spring when the BIA announced that they would be disestablishing a reservation, basically without providing any sort of written notification, right? And that this has been an issue that's been, I believe, in the U.S. District Court. Of course, with the BIA, the Department of Interior is involved as sort of the overarching department. And so, I think that case may point to the fact that recognition, that rights can be reversed, right? That it's sort of an ongoing conversation.
I think your emphasis on ongoing is exactly right. I think a lot of the time we think about Native American history and Native American issues as existing primarily in the past and as things that are settled land claims that, we've resolved. That's unfortunate, but that is something that's fundamentally behind us. And I think for many tribal nations, they would express this, and Native peoples, as ongoing and continual fights and things that have to be sort of continually litigated, continually fought in practice and on the ground. And it's stuff that is, it has very unsettling implications for U.S. land claims in certain places, for jurisdictional questions. Some of this appeared in the recent, Professor Martinko's referencing ongoing court cases in the McGirt decision. If any of you were following the Supreme Court outcomes between this Seminole citizen who was guilty of a crime on Creek land, large portion within what we think of as Oklahoma. Basically, the crux of that Supreme Court case, which was a huge deal for Native folks across the country, was whether or not the Creek Reservation had been disestablished, and so who had jurisdiction to try this crime. But the point of all of this is that these kinds of land claims are not isolated to a single part of the US. They're very hotly contested, and I think, as Professor Martinko is gesturing to, it feels very precarious for Native communities because there's always the risk that in US federal courts, right, which shouldn't be, I don't know, it's a little uncomfortable to think about the fact that the US's interests are almost always opposed to the interests of sovereign Native nations. So the fact that they're being tried in, US Supreme Courts instead of, let's say, in front of the UN or something is a little bit of a stacked deck. But so people are watching all of these court decisions and all of these ongoing battles with tremendous attention because they have these wide-ranging implications for, how we're able to use our land or our water or protect our people on a day-to-day basis.
Yeah, and I mean, as you are speaking to the McGirt decision, I think, that gets us to these broader questions that we hope to address, not just today, but sort of a launching point for this broader discussion about Indigenous histories and their significance for land. And so I'm curious if you could lay out some of the broader implications that you see, perhaps specifically in regards to the McGirt decision, but maybe also more broadly speaking about either litigation or disagreements about land rights that don't fall under formal court decisions.
Yeah, absolutely. So because I realize this is slightly in the weeds if you don't live and breathe Indian law all of the time, as presumably, most normal humans are not. But so basically what happened is that the Supreme Court case arises from a very unfortunate case in which a Seminole man, so a man who is a citizen of the Seminole Nation, committed a really heinous crime, a sex crime, on the land that was part of Muskogee Creek Treaty Reservation. And the way that federal Indian law, and this is the term that we use to talk about the law that binds Native American people, it's called federal Indian law, operates such that if you are Native American of any kind of federally recognized tribe, and you are on tribal land and the crime that you commit impacts another Native person, you are tried in federal court. You are not tried in state court because it's considered outside of the jurisdiction of states. What this means is that basically reservations kind of function like states, so that even if they are within, say, the state of Wyoming or Montana, they are not supposed to have, the state is not supposed to have jurisdiction over what happens on the reservation. So what happened in this court case was that the crime involved multiple Indian citizens on Native land, and it got kicked up through a series of appeals and circuit courts to the Supreme Court because the Jim C. McGirt, the man who was on trial here, said basically, I should be tried in federal court. I should not be tried by the state of Oklahoma for this crime. And the Supreme Court heard this case and basically ruled that he was correct. This had occurred on land that was part of this, I think it's in 1868. Let me look and make sure. Yeah, that it's an 1866 Muskogee Nation, so Creek Nation treaty with the federal government that establishes this big block of land in Oklahoma as belonging to Creeks. Now, where this set people going kind of wild on what is the implication of this is that between Creek Nation, Chickasaw, Choctaw, Seminole, and Cherokee, there is a huge portion of land in what we think of as Oklahoma that encompasses big cities like Tulsa and Tahlequah, that are technically part of these reservations. And what the Supreme Court ruled was because Congress never disestablished these reservations, even if people lost individual chunks of land. So there's lots of non-Native people who now live and work on these lands, who own homes, who have properties and businesses. The reservation technically exists still. And so this means that Native people ought to be tried in federal court if something like this happens. And where this had really serious implications was, as you can imagine, if you woke up and you found out tomorrow that actually the land that you're living on was continuing to be part of Native land that was part of a reservation, that had been signed into agreement more than 100 years ago, folks sort of initially went, oh my goodness, what does this mean for other kinds of crimes, for property, for housing? But the way that federal Indian law works means that it won't impact most people who are not Native. And what it does is to reaffirm the powers of these 5 large tribal governments to try Native people within their court systems, within their own homelands, and to retain certain kinds of control. So the reason that this is super important is that part of the finding of this decision was that even if in practice states or local governments or other institutions have basically bypassed what should be Native rights to regulate these territories, that people behaving in bad faith or not understanding the reservation doesn't negate the rights of Native people to control those lands and those territories. So that's super important, because what the implication of that is that even if other folks have settled on Indigenous land, even if other folks have been breaking federal laws in practice, for long periods of time, that doesn't mean that it extinguishes the right of Native people to govern those territories. And so I think a lot of tribal nations who are now living on reduced reservation land, or who over long periods of time have lost the ability to control certain kinds of resources or certain assets on their traditional homelands, this ruling indicates that the Supreme Court at this point thinks that the letter of the law and the treaties, which the US Constitution refers to as the supreme law of the land, are in fact the things that are most important here and should be upheld. So that these are things that don't get extinguished by bad practices, but that remain, again, the supreme law of the land.
Great. Yeah. And that might be a perfect segue to sort of make comparisons or draw connections with the fight over the Dakota Access Pipeline when we're talking about sort of control of resources and authority over land. So first of all, I'm wondering if you could just give us a very brief definition of what's at stake with the Dakota Access Pipeline. I'm sure many of us have, seen headlines, but there have been sort of a lot of updates of where decisions about this project stand. And then secondly, if you could give us a perspective of, as a historian, how does that help us put fights over the pipeline into maybe a broader perspective and see connections with struggles in other places or perhaps in other times?
Absolutely. So the Dakota Access Pipeline, as you all may or may not remember from 2016, this kind of exploded in the same year as the last presidential election, was a contest over whether Energy Transfer Partners, the company that owned the Dakota Access Pipeline, could run a pipeline and get a permit to go through the traditional lands of the Sioux Nation and on the border of the Standing Rock Sioux tribes' homelands. And the things that were hotly contested in this fight are that this land is clearly part of what should have belonged to Lakota and Dakota people. So in the 1850s, instead of having these 5 different, Rosebud and Cheyenne River and Standing Rock, these different Lakota and Dakota smaller reservations, there was a big chunk of land that the federal government had signed into treaties saying this is going to be reserved as the Great Sioux Nation, so land for Lakota and Dakota people. We will keep all the settlers off of it. It is yours in permanent perpetuity. Then in the 1860s, as the federal government, I'm sure y'all are familiar with what we sometimes think of as Custer's Last Stand or the Battle of Greasy Grass, this massive contest over who had the right to control the Black Hills, where there had recently been found gold during the 1860s and 1870s, resulted in the narrowing of Lakota and Dakota homelands in this new and updated treaty of 1868. So why am I harping on treaties that are more than 100 years old? Because what these do, again, the supreme law of the land, these establish the homelands of Lakota and Dakota people supposed to be in perpetuity and their right to control resources on these lands. And critically, what legal scholars and what both Cheyenne River and the Standing Rock Sioux tribe pointed to was the fact that this 1868 treaty specifically says, even if the reservations are on this smaller section of homeland, I think it's Article 16 of the treaty, this larger original body of land is reserved as unceded and usable for hunting, fishing, and other kinds of resources. And again, I'm saying this is all way in the past, but actually in the 1970s, this was heard as an Indian Claims Commission court case, so a federal court case regarding the theft of the Black Hills from Lakota and Dakota people because the federal government took it by force but didn't ever pay for it. The Indian Claims Commission rules that, yes, this was illegally grabbed, and the Supreme Court upholds this decision in 1980. So if you ask most indigenous law scholars, they would say this is actually about treaty law. And this is a pretty clear, pretty straightforward. Tribes have the right to govern and control the land where the Dakota Access Pipeline is running right now. There's a whole other section of this fight, which again, I'm assuming some of y'all saw the coverage of this from a couple of years ago about the potential impact on drinking water on the reservation, why the pipeline was routed just by Standing Rock when initially it was routed to go north of Bismarck, but was ruled as too likely to be risky to the drinking water of Bismarck. Bismarck, North Dakota is 90% white, unlike the Cheyenne River and Standing Rock Sioux tribe land. But so this became this whole contest on one level over the legal interstices of like, what is it that Standing Rock is able to control? What are their rights to regulate water on one level, an environmental battle? And then on a third level, there was a big question about why it was, you probably saw the coverage again from years ago, if this is jogging your memory, that they were missing the single permit, the last permit to go through Lake Oahe, this final section to complete the pipeline. You might think it's a little strange that they're missing this one little piece of the permit puzzle for this massive multi-million-dollar project. Well, what the company had done was they'd seen what had happened with Keystone Pipeline, the proposals for Keystone Pipeline. And so they went through a permitting process that was designed to do local river crossings instead of a full permitting process for the whole pipeline, which would require an environmental impact statement and federal government oversight and all of this kind of intensive stuff. So they got like 200 of these tiny nationwide 12 permits, one of which was Lake Oahe. Again, the nitty gritty really matters here because one of the other key legal points that the tribe raised was, why is it that you went through this process, which is designed for like, if a building in Villanova wanted to connect to the public sewer and they had to route it over a stream, you wouldn't want to go through all this federal oversight to get something small taken care of. You'd go through like a nationwide 12 permit. This company did hundreds of those to cross all these rivers and circumvent the larger oversight process, which I think, this speaks to the larger conversations we're having nationally about who has access to clean water and when is environmental protection appropriate and where are the boundaries of appropriate oversight. But a lot of this fight came down to this final easement and this contest between the Army Corps of Engineers' ability to grant this permit without either approval from the tribe, which they are supposed to consent to, or federal oversight that would let all of us participate in the environmental impact statement. So basically, there's a stay. An environmental impact statement is in December of 2016, after much legal battle, the federal government decides, okay, yes, we have to do a formal environmental impact statement. We're going to pause the project. Donald Trump gets elected, and as one of his first actions in office, he executive order bypasses this project and approves the final easement. So oil flows through the Dakota Access Pipeline, and Standing Rock and Cheyenne River continue to litigate this in court since then. It's gone back and forth through a number of different district court decisions. I think what's significant is there's already been a minor leak. There have been a number of problems identified with the permitting project. And then in a very unexpected turn of events, in March of this year, a federal district court in DC ruled that they didn't have the proper permits. And so oil had to stop in the Dakota Access Pipeline. That was just reversed in August through a series of, appeals from Energy Transfer Partners. But again, this is an ongoing fight. And actually, there's currently an open, basically the federal government is doing this environmental impact statement, which is what tribes had asked for a long time. And federal comment is now in 2020 open, and it will be open until October 26th. So if you would like to weigh in and have, let the federal government how you feel or whether you think they need to do more environmental assessment or whatever else, that's available now. I think to the question about what are the implications of this and how does this fit in a larger timeline, One of the things that's really striking to me about this is when you hear Lakota or Dakota people talk about this, they start in the 19th century. They start with these hundreds of years of struggle, because for them, the contest has always been over their ability to control this land and to keep their people safe on these homelands, and to maintain the Papasapa, the Black Hills, the heart of everything that is lands that their people consider sacred and holy, and as something that they have what I would call caretaking obligations to, meaning they're responsible for keeping those lands clean, for keeping the animals healthy, and they have connection to those homelands, and their inability to do that is very jarring and sort of violates how they understand their right to belong on those homelands. I think the second thing, you know, beyond the sort of longevity of this fight and the fact that it for them is the same battle that their ancestors fought against General Custer, right, against white settlers in the region, is just the magnitude of this recent phase of contests over Native American rights and homelands. I think Standing Rock really changed the conversation and brought Indian law and litigation to a national consciousness in a way that it hadn't previously. And again, I'm an early American historian, and for years, many years, I would teach courses in early American history, and I would talk about Pontiac's rebellion and these big early American multinational resistance movements, and say, you know, here's all the work it took to do this, here's how they fought with the federal government. Many of these ultimately are defeated, but they're really meaningful in thinking about intertribal, international coalitions. And my students would always ask, well, you know, why isn't that the case today? Why don't tribal nations do that? And I would explain, like, you know, tribal governments have different priorities and there's all kinds of tension between nations. And I was just dead wrong. I would not see coming the hundreds of different nations who signed on to support the Dakota Access Pipeline, which again is about this small permit and this treaty from the 1860s, because they all understood the implications of the larger fight of this, which is basically that if the federal government doesn't respect treaty law, we have very little stake or very little ability to claim our own homelands and to exercise governance there. So even like for my own nation, Peoria, a lot of our tribal members work in oil and gas in the Tulsa and Texas oil industries, or Oklahoma and Texas oil industries. And even though their individual financial interests, their jobs might be larger within the oil industries, they understood the stakes of the fight over sovereignty in the Dakota Access Pipeline, and so signed on to support that. Same thing with Crow, same thing with many other nations. And I think this has created like a moment of shift and resurgence, and the ability of nations to work together in this digital era on digital platforms, right, to take advantage of social media, to organize and to make public what would have, 20 years ago been this small scale minor fight that folks would have had to have fought really hard to even get national attention for. So I think that has really important implications too going forward, because a lot of the conversation around the Dakota Access Pipeline too was, can we set precedent? Can we make this difficult enough? Can we insist that the government follow its own rules and go through proper procedures if they're going to do these kinds of developments? Because we see the long range implications of these contests.
Yeah, but thank you so much for that. And, it's particularly fascinating to think about those connections that you mentioned between the sort of historical instances of building alliances, right? Pontiac's rebellion, for instance, with the No DAPL protests, because I would say probably for non-Indigenous folks, many of us came to sort of hear about No DAPL and about these protests from perhaps local communities, right? From marching in the streets to show solidarity in Philadelphia, right? And whether that was sort of, on the ground or, as you point out, in social media. So I'm wondering, you were in Philadelphia. This has anything about Philadelphia. You were in Philadelphia during 2016, is that correct? And for a couple of years. So I'm wondering if I saw we had at least one question in the comments about Indigenous histories of Philadelphia. I'm wondering if we can sort of wrap up our conversation now before we turn to Q&A, to thinking about Philadelphia, right? Many of us are here in the Delaware River Valley, right, the Lenape-Hoking, and I'm wondering, how can we think about Indigenous histories of this land and perhaps see our community or our region in a different way, or perhaps think about building alliances of solidarity across regions. So any thoughts on Philadelphia and the region, although I know it's not your area of research
Yeah.
specialty?
So I should say I'm joining you all. I'm currently in Minneapolis. So I'm joining you from Anishinaabe and Dakota homelands, but I usually live and work and also in Lenape homelands, different part of Lenape, but up in New York City. And one of the things that I think is really striking about, Philadelphia and New York, sort of the greater Lenape homeland region, is just how immense the dispersal of Lenape descendants is, right? There are Lenape communities in Canada. There are Lenape communities, Delaware communities in Wisconsin. There are Delaware tribes who went through a series of many removals to end up in Oklahoma. And again, there are local Lenape groups who remain in New Jersey and in and around original homelands. And I think, actually this gets back to the very beginning of our conversation about why recognition, why these different histories, and what happens. I saw in one of the questions in the chat a reference to William Penn and the 6 different groups. One of the things that as an early American historian I see again and again and again is that newcomers, European settlers, really are struggling to understand who controls the land, whose land exactly they're on, and what the jurisdictional things are. In part, this is because Europe, as we will later on think about land as being this exclusive, nation state, hard boundary place, Lenape is really just this very large term for a whole sort of language and cultural group. But within this, there are much smaller groups that would have been in control of your daily sort of political functioning, land use, society, family, etc. And so the question about, could William Penn have purchased land from 6 different groups? Absolutely. So I had mentioned when I was talking about caretaking obligations for the Dakotas and Lakota relationship to the Black Hills and homelands. I think one of the things that's really striking is that, and I see this in my own work in the Lower Mississippi Valley, is that it is possible for different groups to both use what we would think of as natural resources on the same territory and to have overlapping, what we would think of as claims, or living in very close proximity in their homelands. And this worked with many traditional forms of tribal governance because there wasn't this sort of exclusionary logic in the same way that we will later come to think of it as in a European sort of nation state formation, but that basically Native people understood what belonged to them and who had rights to use that, but that it could be used by other groups or newcomers, folks who came into the region and settled there, as long as they had relationships with the original group and they were doing appropriate caretaking of the land. So I think to Philadelphia and, sort of the broader Pennsylvania history, it's an interesting and an unusual one, in part because you don't have the brutality of somewhere like Virginia or Massachusetts, where there really are these massive, super bloody early wars in which settlers drive folks out. You have this sort of initial attempted negotiation and coexistence, at living alongside each other, and treaty sessions. But by the time of the American Revolution, central Pennsylvania, western Pennsylvania has become pretty blood-soaked by settler expansion and incursion. And that's not something that's, I think it's almost sometimes harder to see the slow violence of settler movements and the individual sort of pushing out of Native people than it is if there's something big like King Philip's War, or the war between Virginians and Powhatan's, folks in the 1620s. Like it looks different in Pennsylvania, but one of the things that I think is super interesting about the city and the space is that it's still regarded by many Lenape people, right, as the center of homeland. So it's not somewhere that they've severed connection, and that now Philadelphia has many indigenous migrants from all over. Right, so from South and Central America, from across the country. And so there's a different kind of indigenous community relating to original Lenape people in that space, which leads to a very sort of interesting and layered kind of indigenous community in the region. So I think as an early Americanist, one of the things that I think is happening and that I've been very excited to see in and around Philadelphia is that beyond just the celebration of early America and William Penn and Benjamin Franklin and our kind of icons of early American history, there's increasingly attention to this indigenous history and this indigenous persistence in Pennsylvania. And I think that that's a really significant change and something that's really important for framing how we think about, the city, because I don't know that anyone would have thought of it as Lenape country maybe 20 or 30 years ago, even who wasn't Native. Does that jive with that?
Yeah, and to think about too what you were mentioning, the ways that migration has shaped sort of more broadly the indigenous histories of Philadelphia. If we think about Mohawk ironworkers who built the Ben Franklin Bridge in the 1920s, or I think there's a fairly significant Lumbee community of migrants in the mid 20th century. And so, the Penn in the Lenape of the 1680s and 1690s are one part of a history, but it's a long and ongoing one that's quite diverse, as you mentioned. Wow, thank you so much. So I think it's probably time now to turn to Q&A. I will be moderating. So again, as a reminder, you can use the raise hand icon to ask a question, or you're also welcome to put a question in the chat as well. Any questions for Dr. Ellis? Okay, I see Dr. Kolsky. I see a video hand.
I think I can't raise my hand because I'm the host.
Right, co-host.
Yes, I'm the co-host. So thank you, Professor Ellis. Fantastic presentation, super interesting. And your talk has me thinking about whether law is the solution or law is the problem. So I'm a historian of law and colonialism. And when you look, and I think for many people, there's an easy equation between law and justice, right? When we say we want justice, we often mean we want to go to court and we want a just resolution of our claim. But when you look at the history of law and colonialism, law is what creates the colonial state. Law is what maintains the colonial state. Law is what justifies the colonial state. I mean, Mohandas Gandhi made this point very clearly in 1909, a trained lawyer who basically said, without law, the English could not hold us for a moment. And he urged people to not cooperate with law courts, because every time you go to the law court, you reinforce and you justify and you recognize the authority of the British. And so when I read your chapter, and you make this very clear in your chapter that the Sioux have, in this case, undeniable legal rights. It's an unusual case. And yet, that doesn't seem to be stopping Trump. And so, in the article you make this, I think you present a vision of different modes, 21st century modes of dealing with a sovereignty question that are not necessarily built in and around legal claims. So I'm just wondering what you might say about, I'm thinking of Audre Lorde, that famous poem, the master's tools will never dismantle the master's house. Law is the master's tool, right? I mean, these treaties, even seeking that there's a game being played on the master's board. At least that's kind of how I see it. So I'm wondering what you think about that. Is law the solution or is law the problem?
Yeah, I absolutely love that question. And part of what I love about it is it's one of the things that's being very hotly debated currently, right? Between folks, say, in tribal government who are, for practical purposes, used to dealing with the US state all of the time. And so we're saying, we need to protect our people by any means we can. This is a way that helps ensure that we have funding and we have support and we're not dealing with federal military stomping into our homelands. And then there's another conversation more in line with what you're saying, which is just, this is not built for us to win. This isn't designed to uphold our claims, to uphold our sovereignty, and to support our kinds of modes of justice. And I think, there's been increasingly conversations, like I referenced, about should these court cases be going before the UN, or should we be, Audra Simpson, who's a Mohawk theorist, talks about the politics of refusal. And she's specifically talking about Haudenosaunee, or so Iroquois, folks who refuse to comply with borders, refuse to recognize US citizenship, travel on Haudenosaunee passports, right? Say basically, I'm not dealing with any part of this system. I refuse to be complicit in this because I don't recognize your sovereignty here. That's another aim here. And then there's an on the ground ethos of like, okay, so law exists, jurisdiction exists, but what if you can continue to perform those caretaking obligations? What if you can continue to show up as your body and to act as though these strictures, right, don't apply to you, which I think is also part of the strategy for the Dakota Access Pipeline, was just the public should understand the ethos here, right? If we can get people to come out and put their bodies on this territory and to help us uphold these, the way that we should be able to control our rivers, this is a way to challenge the state that doesn't go through a legal system, right? So that there are many different avenues. And I think that this is an incredibly important issue, and one that, I think is sort of very apropos of our current moment in light of, right, our ongoing uprisings and Black resistance across the country, and the question of like what happens when law does not protect you and does not protect your family and doesn't protect your people. What are your other modes of justice? And I think one of the things too that's like wonderful about this question and the specificity of this case is that actually part of the reason I started talking about how folks go to federal court for Indigenous folks if we commit crimes on tribal homelands. Part of what stripped Native people of jurisdiction to try really serious crimes like murder, rape, super violent assault was that in the 1860s, this is actually on Lakota and Dakota homeland, crow dog versus spotted tail. Basically, one Lakota man kills another Lakota man, and the basically tribal governance says to them, okay, you now owe restitution to that man's family. So it is your obligation, your punishment for killing this other man is you have to supply his wife, his children, his extended family, and make sure they are not hungry, make sure they are fed. And the Indian agent who was on this case found this to be barbaric. And so he wrote a complaint and he sent this to back to the federal government. It went up through the Supreme Court, and they ruled that, yeah, for all intents and purposes, Native people are allowed to try this on their own homelands. And so the Congress passed the Major Crimes Act, which stripped Native people of their ability to have this kind of jurisdiction to regulate their own because of the barbarity and the savagery of these practices that were not, in line with at that time period. If you committed murder in the Western Territories, you were sentenced to be hanged or executed otherwise. And so I think these mismatches of justice and these mismatches of Indigenous theory that thinks about, thinks about rivers and other kinds of lands as having certain rights inherent to themselves, and Western law, which would categorize these as natural resources and possessions and things that can be managed for people's good. So yeah, I don't have a solution, but I think that that's exactly where the conversation is, and something that's really important for people like you who work on law and colonialism and theory to kind of work through the implications of these different approaches to justice.
Great. So we've got a couple of questions following on this. One asking, how do we get around the US government ruling on issues with clear conflicts of interest? How could we get the UN involved? And then following on that, when and or pertaining to what aspect can it be deemed a violation of human rights? Some of these disagreements over resources, environmental justice, and impacts.
Yeah, I think for, again, to point to the Dakota Access Pipeline fight, there were UN observers on the ground who were writing, concerned reports about the use of force against Native people. To stress again, there were reports that people were held in dog cages. There were private security firms that released attack dogs on unarmed people along the pipeline. We turned long-range acoustic devices and water cannon and messed with internet. These are things that you would think of generally as being applied to overseas military conflicts, although traditionally, though, that's the same kind of weaponry that we've turned on Indigenous and other people within the American state. But basically, there was tremendous use of force in ways that were very disturbing. And I think the question about the UN is very appropriate, because it's very hard for the UN, right, to enforce things on the ground against powerful states. So observers are in there, they're writing about concerns about the treatment of Indigenous people. There's been larger contests over whether or not, the United States is supporting or in line with the UN Declaration on the Rights of Indigenous People, UNDRIP, right, which basically says that we should be able to consent to things that affect our territories. I would say the US is in violation of many of these things, but the question is, what are the practical consequences? And I think there are interesting past examples where during the Cold War, for example, Seminole and some other groups sent representatives to Cuba and were dealing with the USSR and being like, well, this kind of a trash government we have here, and you're fighting this epic war with, these communists abroad. What if we sent representatives and said, well, the federal government's very seriously mistreating us, what are our options? And that didn't exactly pan out. But I think that I point to that as a way to think about international approaches for Native nations and other kinds of places that tribal nations can seek redress. And again, I think this points to the, coalition building across different indigenous groups who are showing up to lobby and support each other. But yeah, I don't have a good answer for how to make sure that this is internationally regulated in a way that's more fair to indigenous people. And I don't think it's specific to the US. We can look at Brazil, we can look at Mexico, we can look at a lot of settler states and see kind of similar parallels and fights.
Yeah, thank you. I had a quick question, actually, particularly because this conversation in some ways is setting up the broader conversation for the month. And that's a question about land acknowledgements. I think land acknowledgements at the beginning of talks, or land acknowledgements as sort of institutional statements, whether it be for universities or houses of worship, any institution really, are becoming more common, I would say, particularly in certain regions. But I'm curious how you see land acknowledgements, is because of course there is the pushback to say that these are performative, or it's very easy to sort of acknowledge a homeland without actually engaging with any descendant communities. So I'm curious what your thoughts are on land acknowledgements. Can they be a good thing? Can they be a bad thing and do harm? And perhaps how do we deal with them in this digital era where here we are meeting in a single place, but from all over the world potentially?
Yeah, and I mean, just in case you're not familiar with this as a practice, I think for formal meetings, for public talks, if I was, for example, at my home institution in New York City, I might, as I welcome people and introduce presenters, gesture to the fact that we're all on Lenape homelands. This remains a center of Lenape community. And that New York City actually has a population of over 100,000 Native American folks in the city alone, with a much larger indigenous population. So that I think it's basically productive to think of it as an indigenous space. And probably I would say something connecting to whatever the conversation is. Frequently land acknowledgements can be shorter than that, more like what I did in the middle of this presentation, where I just noted that I was on Anishinaabe and Dakota homelands, which is where I'm calling you. I think the purpose of land acknowledgements was to help folks understand that we are all standing, if you are in the US, on Native land, on somebody's homeland. And that one of the easiest things we can do to start to think about what that means and accountability is to figure out whose homeland are you living on, whose homeland are you working on. And I think that this has become institutionalized, right, as a way to just gesture at the importance of Native people and move forward for sure. But I also think it's a really powerful thing if you take it seriously, meaning that if you say, okay, I'm in Tulsa, which is one of those places I just talked about, and I'm on Creek Nation territory. What does that mean in terms of your conduct and your behavior? Well, for example, if you knew that there was an obvious sacred site nearby, if you knew that Creek people were fighting to protect some kind of water, if you knew that your neighbors were struggling, you might think about being in relation to the people whose homeland you live on. Meaning basically with an indigenous perspective, you might have accountability or obligation or want to be engaged with that community as someone who you see as your neighbors, the same people you work with, in the same way that you probably try and be a reasonable neighbor in Philadelphia, right? And not, unnecessarily blast your speakers in the middle of the night or leave huge piles of trash everywhere. I mean, it's the basic ethos of can you be a good relation would be how we'd put it in indigenous context. And so where I think land acknowledgements are useful is as a introductory sort of series of remarks as a way to tell a history. If you live in a place that's complicated, like where our tribal lands are in Oklahoma, we share territory with Ottawa, which is a different Indigenous nation, and we're actually resettled on Osage territory. So we're living in this interstices of different kinds of Native belonging, which would just mean that we have to be good relatives to the people whose lands we share and coexist on. And I think this is a lot of what's behind the thinking about whose place are you in? What's the purpose of acknowledging this? And once you've done that first step, there's a great website. It's called native-land.ca. And you can just kind of Google in there, like, whose land am I on? It's not perfect. It has some big gaps, like the lower Mississippi Valley, but it's super helpful as it just kind of like, oh, what are the specific groups that are where I am or where I grew up? And I think that can be helpful for thinking about grounding in a place and imagining, you know, where you live and work is somewhere different than just being accountable to Philadelphia or Pennsylvania or whatever your immediate neighborhood group is.
Great, thank you. Any other final questions for Dr. Ellis? I see a question here about Congress. Sort of, it's related, I think, to this question about, you know, using the tools of the master or not. So the question is, although deeply underrepresented, Native Americans have served in Congress since the early 1800s and until today, how does one grapple between leveraging political power legally and logistically and protecting Native lands and people and this resistance to legitimize or recognize the colonial system itself?
Yeah, there's actually, so Cherokee Nation had in one of their treaties from the 19th century this amazing provision which gives them the right to send a representative to Congress. So this isn't a voting member, but it's someone who sits in and has space to speak in Congress. And that's very in line with the way that Cherokee Nation attempted to deal with the federal government and enforce borders, and basically has always been deeply invested in trying to use the US legal and economic system as a way to defend its people. And I think that's a really interesting, you know, kind of avenue to think forward with, which is like, what if you know, we're running the census for tribal nations? What would it mean to give a Native people living on these lands meaningful representation within our governing body? That's not something that was built into our governance structures because we assumed that Indigenous people would die off, get bled out, and sort of evaporate their claims from territory. Like the US system was not built to continue to have Indigenous land title in 2020. That was not the original intention here, which has created a sticky legal mess. But if you look at, I mean, state and local and increasingly, you know, House representatives, there's actually a considerable amount of Indigenous people running for representatives. And I think, running for like representation of their state congressional district or at local levels. And I think this is an interesting approach, not an interesting approach, but a significant approach of a group of Native folks who've said, you know, we can represent people who aren't just Native Americans, right? Sharice Davis can represent the people of Kansas and be accountable to people who are not just Indigenous, but she can also occupy that space to advocate for larger issues like missing and murdered Indigenous women in Congress. And so while you have a block, I think this gets back to Professor Kolsky's question, while you have a block of people saying, you know, maybe I do vote, maybe I don't vote, maybe I recognize my US citizenship, maybe I try and travel on my own people's passport, you have another block of Native people saying, okay, what's most practical and what's going to help immediately for the communities that I care about and I live in now? I want to be represented. I want to participate in Congress. And as, you know, an American citizen, here's how I want to serve my country and my community. So I think it continues to be that split. And personally, I think you need both approaches. I'm very much like, you need one ideological section, and then you need a group of people who are willing to go deal with the nitty gritty of legal documents and tribal governance structures. So I think they're both very productive, but yeah, should be an interesting.
And maybe one final question to wrap up today, a question to speak briefly a bit more about the Haudenosaunee refusal to recognize borders. And maybe that's an example of the way that borders cross people, not just that, well, I'll let you sort of speak to that specific example and the broader implications of it.
Totally. So Haudenosaunee Iroquois people, which would be Seneca, Onondaga, Oneida, Cayuga, and Mohawk, Tuscarora, sorry, this is the Six Nations, are they were one of the most powerful blocks of indigenous confederacies in the 17th, 18th centuries, even before that. And so what that meant was that as the United States was formed, they were continuing with this really powerful indigenous confederacy on what would become the northern border of the United States. And so in the years after the American Revolution, when I referenced Pontiac's rebellion, there's a whole series of indigenous resistance in the old Northwest territories. So what would be Ohio, Illinois, the Great Lakes, that are basically fighting against the expansion of the nascent U.S. Republic. But Haudenosaunee people are continuing to be, they fought on both sides in the American Revolution, so some of them for the Patriot cause, some of them for a British cause, but they've maintained this territory. And in the 1790s, the U.S. is so weak that they're able to negotiate a very fixed, again, one of these treaties that says, if we create new boundaries between Canada, it's controlled by Britain at this point, in the US, this shouldn't impact Haudenosaunee territory. We recognize it through upstate New York, and Haudenosaunee, other indigenous people, can travel back and forth across the US and Canadian border. Now, interestingly, the US continues to recognize that today, so that if you are Indigenous, so First Nations, there's a weird blood quantum provision where you have to be more than 50% Indian blood coming from Canada, which is a whole other conversation, maybe for another time. But that basically folks can continue to cross the border as they see fit to live, work, and they cannot be deported. Canada, by contrast, doesn't recognize that in the inverse. They claim the War of 1812 sort of dissolved that provision. Why am I talking about the borders and all of this sort of stuff? This gets to the heart of what I would think of as a Haudenosaunee claim, as basically, we pre-existed the United States. We are a powerful republic. You came afterwards. You drew a border through the middle of our territory, and none of that impacts us, right? We have always lived here. We have built and we had a democracy, or a republic rather, before you guys formed yours. And so we have the right to continue to exist here. Many Haudenosaunee people rejected US citizenship in 1924. Famously, and I'm forgetting who this is a quote from, but a Haudenosaunee intellectual said it's the kind of same thing as if the US woke up tomorrow and passed a law making all Mexicans US citizens, right? A whole bunch of people would sit up and be like, no, no thanks, you keep that. And that's kind of what's been the contest within Haudenosaunee, and in particular Mohawk homelands, which cross the US and Canadian border, where folks insist on traveling on Haudenosaunee passports and insist on, saying basically this border and the taxes, all of the surveillance shouldn't apply to us because we have had rights to live and work here from long before either of you all was an existing country. And so that's very much an ongoing issue at the moment, has been for hundreds of years, but I think is a good example of the kind of refusal. And Audra Simpson, again, who's a Mohawk feminist and intellectual anthropologist, has a book called Mohawk Interruptus, which delves into a lot of these issues of refusal that I think, if you're interested in this, would be super helpful. And I bet now there's like someone Haudenosaunee on this call that I should have tagged in to answer this question instead of this, but that's the one thing about being online, right? It's hard to sort of see who all is here, and I'm sure that there are a lot of people who could have joined the conversation today. But you'll have to until next week, so that'll be perfect.
Exactly.
It's exactly going to be my point. I promised timeliness, and so
yes, and we're out of time.
I'm going to jump in. I'm going to give a hearty thank you to Professor Ellis, who delivered in this beautiful and direct way this complex history, and we're very grateful to you for your knowledge, your wisdom, and your time. I'd also like to thank my wonderful colleague, Whitney Martinko, for doing a fabulous job at moderating. Dr. Martinko will be back with us same time, day, Wednesday, the 21st at 12:30 p.m. We're going to kind of carry the conversation forward. Next week, for those of you interested in this question of law, we have a conversation with an international panel of experts. Doug Keel, who's a historian at Northwestern, who's actually worked on, and I think served as an expert witness on the Oklahoma case that Professor Ellis mentioned. We have John Maynard, who's a professor of Indigenous history in Australia and has done comparative work on Aboriginal people and Indigenous peoples in North America. And we have Tembeka Ngukai-Toby, who is a human rights lawyer and a very prominent legal historian in South Africa, who's done work on sort of South African land claims and white settler colonialism in South Africa. So we hope you will join us. I put a link in the chat. The event is next Wednesday at 6 p.m. Dr. Martinko's event will be the following Wednesday at 12:30. Professor Ellis, we'd love for you to join us. You could be that person in the audience who we don't know is here.
Perfect.
So thank you all so much. Hope to see you next week. We appreciate your time and see you soon.
Thank you so much.
Okay, bye-bye.